Thank you, Shona, and good to be here again. Again, just a few more cases that hopefully you'll find of interest and hopefully of some use. The first case I want to chat about was, it may not be much practical use to you, but it excites the likes of me who doesn't get out much. And it's all to do with the correct technical way of dealing with appeals from decisions of the accountant in bankruptcy to the sheriff, and how they should be dealt with if those appeals are successful. And this is, again, an unreported decision at Kirkcaldy Sheriff Court. And the background to it was quite a lengthy case, actually. I think it started back in 2013. In 2014, the trustee had submitted his accounts. The accountant in bankruptcy had rejected them, and there had then been an appeal before the sheriff. Ultimately, what happened was, in that case, it had become quite granular to the extent that, excuse me, ultimately what was being fought about was almost the account on a kind of line-by-line basis. And as you might imagine, the sheriff wasn't really up for that. And ultimately, how it settled was that accountant bankruptcy, the trustee agreed that they would appoint another insolvency practitioner to go through the account and to make certain recommendations, and the parties agreed to abide by that, and that was how it was sorted out. So that was back in 2016. And what happened after that was that the trustee then had to raise an action to recover the debtor's family home. I think it was a farm. It was quite bitterly contested, and it wasn't actually resolved until after an appeal. So it would have been, I think, after quite some time, the trustee submitted his account to the accountant in bankruptcy. Now, there were two issues that arose in this. One was, well, firstly, the account was cut down by the accountant in bankruptcy for two reasons. Firstly, the accountant, so the insolvency practitioner, had included in his account his legal fees for the first dispute back in 2014 to 2016 to sort out his fees. And the accountant in bankruptcy said, well, you can't have that. Those are not fees that are reasonable in the context of the sequestration. That was for your benefit, so you can't have those. And despite the fact that the trustee had put them in the account a number of times, in this occasion, the trustee agreed that no, they were not a valid charge and they should come out. But in relation to the balance, the issue was really one more of vouching, because the accountant in bankruptcy wasn't satisfied that the agent had properly vouched what were quite substantial amounts of legal fees, something like £28,000, I think, could be vouched. Ultimately, the trustee raised an appeal, and ultimately what happened was it was agreed that once this voucher was produced, that in actual fact the trustee was entitled to charge these fees. Now, the question was then, well, how do we deal with this? It was always open to the trustee to include these in his account the following year, but as you might imagine, the accountant wasn't all that, or that the agent wasn't all that keen in doing that. He wanted to have his accounts approved so that he could take the funds now and settle legal agents and the like. So it was agreed that the appeal should be allowed to the extent that it was agreed. The question then became, well, how should the sheriff deal with that? Should the sheriff issue a judgment saying that that's what the final amount of the account should be, or should the sheriff remit the case back to the accountant in bankruptcy to issue the determination? The trustee wanted the matter to be dealt with by the sheriff, and the accountant in bankruptcy wanted the matter to be remitted. Now, we had a brief debate before the sheriff, and I had argued that the situation was very similar to the situation that arises in DAS cases. Because if you look at the terms of legislation, it's not actually very clear as to what should happen if an appeal is successful. But in DAS cases, well, similarly, it's not clear what should happen, but the court has determined that in those cases, if an appeal is upheld, it should then be remitted back to the accountant in bankruptcy as DAS administrator to make the decision, sometimes with guidance or with directions from the sheriff. And in this particular case, that's what I said ought to happen. And one of the compelling factors I said was that if the sheriff was to issue a determination that the accountant bankruptcy wouldn't be entitled to charge the statutory fee that would be due on this increased amount of the account, and ultimately the sheriff agreed that my interpretation was correct, it was remitted back to the accountant bankruptcy to make the determination. Now, as I say, it's a relatively, perhaps a technical geeky point, but I think it is important that if you are appealing a matter in relation to accounts, you have to be aware that if you're not happy with what the accountant bankruptcy has done, you appeal it to the sheriff, and you're successful, the matter should be remitted back to the IB. And just as if the account goes up in your favour, that would mean that there's a bigger amount goes to the accountant bankruptcy. Similarly, if your account drops, that would then mean that it goes back to the IB, and there's a lesser amount would have to be paid to the EIB under the statutory fees. So therefore, I suppose you would have a duty to creditors to make sure that that happened, so that there was not an excess amount being taken out of the sequestrated estate. The next case was a case that we had up in Kirkcaldy Sheriff Court. It was a division and sale, and the background to this was that the debtor was sequestrated in December 2019, with a warrant to cite having been issued in November 2019. Slightly unusual in that the debtor, for some reason, had 6/10 of the title, and his partner had 4/10. They weren't married, but they had a child together, so therefore the property was a family home. There was equity of about 107,000, and the debtor's share was about 64,000 against debts of 69,000. Now, this was a case, I know that trustees sometimes get a bit concerned that the court might not grant orders if there's issues in relation to health, particularly in relation to children. And in this particular case, the whole family had health issues. I think the debtor had low mood depression, asthma, mild osteoarthritis. Partner also had anxiety and depression, hydrantitis suppurativa, don't know what that is, and intermittent back pain, sounds like myself. And the child had tendinitis and hormonal migraines. And this was a case where two aspects, I think, come out of this. One was that the solicitor who was acting for the debtor just lodged the whole records, their whole medical records, that like from like when they were born to the date of the proof, and didn't actually make any attempt to narrow down and specify what the issues were, and for that reason these arguments were all rejected. And that's something that we relied on. You might recall the case of the Sheriff Appeal Court decision in the case of the accountant bankruptcy against Brooks, and in that case Sheriff Holligan, who issued the decision, remarked that it's not for the accountant bankruptcy, or rather the trustee, to say why a property shouldn't be sold. It's for the person who wants to rely on the provisions of section 113 to set that out. In this particular case, despite the fact it was alleged that there were like serious health issues, it wasn't enough to simply plonk down a whole bunch of medical records and ask the sheriff to infer from that it was not reasonable to sell. There remains an onus on that party to show what the defence is. And that's why, and again in that case, despite the fact that there was evidence that there was health issues, the sheriff still granted orders for sale after a bit of procedural toing and froing. We've actually got orders, and I think that the debtor has now been ejected from the property and eventually moved voluntarily. But the point is that just because there may very well be health issues, it doesn't necessarily mean that the court is not going to grant consent. Indeed, my view is and has always been that only in the rarest of cases must the consent be refused. And you must remember that going back to the case of McMahon's trustees against McMahon's, one of the overriding factors is that the court must not make a decision that would do lasting harm to the interests of the creditors. And in fact, we have a case at the moment where one of the spouses arguing that not granting orders would not do lasting harm to HMRC because they collect billions and billions of pounds. If that was the case, we'd never get to evict anybody. Now, in my view, that's not the way to interpret this point about what is lasting harm. The way that you view that is a much more narrow term, as in will you do lasting harm to the creditor in respect of this one debt? And the answer to that is always, well, yes, you will, because if that debt won't get paid, it will suffer lasting harm. And I certainly had a case many years ago with an appeal before Sheriff Principal Scott, and although he didn't necessarily issue a decision that coincided with that, he was broadly in agreement that that was the correct way to deal with that aspect of the case. A reported case was that of Spate against an accountant in bankruptcy. And the background to this is that I think the data had been sequestrated some time ago. There had been various issues, but eventually the agent for the accountant in bankruptcy had adjudicated on the claims and had allowed a huge number of claims. Now, what happened was that the decision letter issued by or rather, I should say that after that had happened, the debtor applied to the accountant in bankruptcy for a review of the adjudication, and the accountant in bankruptcy, having considered matters and having heard representations from the debtor, upheld the decision of the agent and upheld the adjudication. Now, the determination letter was issued in August of 2020, but the debtor did not then appeal to Sheriff until August 2022. The Sheriff refused the appeal, and the debtor then appealed to the Sheriff Principal. Now, the Sheriff Principal refused the appeal as is coming too late. Now, in that case, the debtor made reference to Section 211 and said that it was open to the court to extend the period having regards to Section 211. Now, what in that case, the argument that was briefly made was that Section 211 doesn't work that way. Section 211, and I'll come back to this, Section 211 is quite prescriptive in its terms. He didn't accept that that was the case. Sheriff Principal Ross took the view that he could use Section 211 to hear this application, although late. But having done that, he decided he would apply his discretion in the usual way, and on the basis that this appeal did come so very, very late, he just simply wasn't prepared to countenance it. Now, as I say, I think that with respect to Sheriff Principal Ross, he was wrong in deciding that Section 211 could be used to allow the debtor to lodge his appeal although late. Now, those of you of a certain age might recall that there was a kind of a discussion or kind of line of thought arising in relation to whether or not Section 63, as it was, you know that Section 63, that we're the kind of catch-all there, is that it allows the court to excuse the failure to do something if it allows something that needs to be done. And the question has always been, well, how wide is that? Now, in the case of Clydesdale Bank against Davidson, this was a case that was issued in Scottish Civil Law Reports. There was a commentary at the bottom of that by, I think it was Sheriff Principal Stewart, and he drew a distinction between provisions in the Act that you must do and those that you might like to do. So an example of that is that a trustee must lodge accounts timorously and go through the whole adjudication process at a certain time, and that's the requirement. But just because someone might want to appeal a decision, that's not a requirement. And in that, you can see the difference between things that you must do and things that you might like to do. And the decision of, or kind of view of Sheriff Principal was that Section 63, now Section 211 and Section 212, if you're dealing with decisions made by the accountant in bankruptcy, is that those provisions are only there to allow you to do things that you must do that for one reason or another you've not done timorously or you've forgotten to do. And I find support from that. And there's a case, Patullo against accountant in bankruptcy in the sequestration of Macleod. And that was a case, again, it wasn't completely in point because no application was made in terms of Section 63, but Sheriff Holligan made the point that, you know, it's really not open. Like the Act sets down a fixed timetable, and it's not for the court to start interfering with that. And similarly, in the unreported case of it was Manhen Lou against Hastings, Sheriff Deutsch adhered to that view too, that Section 63 is there to allow you to do things you must do, not there to allow you things you might like to do but you're late. And we also find some support from that in Don Mackenzie's Schemes book at paragraph 61, 31, and also in McBride and Bankruptcy, paragraph 162. And as McBride says, Section 63 does not allow the sheriff to rewrite the Act, even although there's a subsidiary power to waive a time limit. So, as I say, the decision of Sheriff Principal Ross is there. To an extent, it's not necessarily binding because it is a decision of just one Sheriff Principal rather than being a decision of a fully convened bench of 3 Sheriff Principal. And also, he wasn't taken through all of these authorities. But that having been said, Sheriff Principal Ross seems to think that Section 211 and Section 212 are quite wide, albeit I don't think that they are, but he's a Sheriff Principal and I'm not. But in any event, with that, I will hand you back to Shona. Thank you.